Good afternoon, everybody. Welcome back to another episode of Stewarts Soundbites. Just while we wait for people to filter in, just a shout out to all of the parents who, like me, have been counting down to the end of the summer holidays. We're 1 week away from drop kicking those kids back over the school fence. So well done, everyone. We are nearly there. Let's dive in, because as usual we've got 15 minutes today when really we need about 3 days to cover the topic. Today we're talking about stress for claimants in personal injury actions. We're joined by Dan Herman, who is a partner and the head of the personal injury department at Stewarts. I'm sure everybody watching knows that. So thank you for joining us, Dan. Dan's youthful good looks are deceptive. He's got many years of experience under his belt in dealing with personal injury proceedings, and has a huge amount of knowledge, which will come through during the discussion today. Dan, it's trite, really, isn't it, to say that PI litigation brings with it an enormous amount of stress for claimants. We all know that. You know, we deal with the most seriously injured individuals, and not only has their life and the lives of their families been completely upended, but you know, there's a grueling litigation process hanging over them, usually for a number of years. And in preparing for this session, I was thinking about kind of the various stages, and we'll go into that. And I was thinking about kind of those acute stages are, well, we know already, horrifically stressful. Usually a long and stressful hospital admission, and the kind of uncertainty about discharge. Can you go home? Can you go back to work? How are finances going to work? All of that sort of thing, and totally varies depending on individual circumstances. And I suppose I wanted to kick off, Dan, just by acknowledging that, but also saying that we're not going to talk about the things that we kind of already we know, all of those things I've just mentioned. But I do want to start, I suppose, with an obvious question, but a good starting point, and it reflects upon your experience, Dan. And what are the main reasons that litigation adds such significant layers of stress for claimants?
Thanks, Emma, and hi everyone. No, you're absolutely right. I mean, we have to acknowledge the fact that anyone who's sustained a life-changing injury, that in and of itself is hugely stressful. Even if you ignore any litigation claim, you know, the people's lives have been turned upside down, not just their lives, but their families' lives. But the litigation itself does bring an added layer of stress, a particular type of stress, which has been called critogenic harm, critogenic stress which is actually generated by the litigation itself. There haven't been a huge number of studies. There've been a few. They're mainly studies in the US, but they are out there, and I can flag them for people if they would like to read them. But one is called literally litigation as violence. That's the name of the study. And for many of our clients, it is or can be quite a violent process.
Mm.
You know, a stress-laden process. When we have an adversarial system in this country, the burden is on the claimant to prove their case. And whilst there have been really improvements with the interaction between claimant and defendant lawyers through the rehab code, the serious injury guide, and other protocols, you know, it is an adversarial system. The claimant is under the microscope, and that can bring about stress. I suppose what these studies suggest is there's three main reasons why litigation induces stress in claimants. And throughout the litigation process, claimants will feel one or more of these stressors at multiple points during the case. So the first is a lack of control. So the claimant either isn't or doesn't perceive themselves as being in control of the process. They've got to cede some control to their lawyers who are representing them. The defendant's legal team can exercise a degree of control over certain elements of the process, and ultimately, a court can determine things, either an individual issue like an interim payment or the entire case. So there's a lack of control there. As we'll come on to see throughout our talk today, there's a real question about invasion of privacy and about a claimant's whole life being available to, you know, potentially dozens of people to leaf through some of the most intimate and personal information about them. And then there's uncertainty. Uncertainty causes stress. I mean, uncertainty about a whole range of things, but some of the fundamental building blocks of a case. Will I win my case?
Mm.
How long will it take? How much will I get? Those things, certainly at the outset, may not be certain, and there may be uncertainty about that for a long period of time. And all these things working together can cause huge stress in claimants. And one of the things we'll go on to discuss, I'm sure, today is how we can go about managing that stress or mitigating that stress.
Yeah. We it springs to mind, Dan, that we have posted some videos recently. I'll get them to in the recording of this episode when it is posted. We'll link some of the videos that we've produced about some of those big questions
Mm,
at the beginning of cases, which inevitably come up and generate a huge amount of stress. And we've done a couple of short videos which deal with those specifics. So I'll link those if anyone's interested. And if anyone's interested in the studies that Dan's mentioned or the links, again, message me and I'll make sure that we have the links. Just to sidestep a little bit, Dan, and it does tie in with a couple of things that you've already touched upon. I wanted just briefly to touch upon funding at this
mm,
point, because that is, in 99% of the cases we see a huge concern from the outset. And it ties in with this the element of uncertainty and lack
yeah.
of control that you've already mentioned. But um, there are some cases where, the claimant benefits from an early interim payment on their case, and there are other cases where that is not the case.
Mm,
It's not my experience that having an interim payment early kind of deals with an answer as an answer to all the kind of stress and worry
yeah.
dissipating.
Mm.
And it strikes me that actually both of those scenarios can generate stress in their own way.
Yeah, I mean, we see it all the time, don't we? That one of the biggest focuses for clients and for us at the early stages of cases is securing that funding, because the funding can open up so many options to clients, particularly, in that process of discharge from hospital to home, whether it be to care, accommodation, transport, you name it. It does make options available to claimants, and the lack of funding can be a real stress for claimants, or sometimes the hoops that insurers make claimants jump through before they'll release the funding can cause
Yeah.
real stress. But you're right, even if funding is available, that doesn't mean that the stress goes away.
Mm.
If the claimant has got funding via the rehab code, the joint instruction of a case manager, for example, that's great, but it doesn't remove the stress, because the claimant can feel a lack of control. The defendant holds the purse strings, although the
Yeah.
funding is available there in theory. The defendant insurer can still say, well, we'll agree this, but we'll not agree that. Or we'll agree X number of sessions, but we won't agree Y. So that lack of control can cause stress. And then, if an interim payment is released by the defendant and the claimant's got control over how to spend that interim payment, there's still stress because, well, two main reasons. The first is uncertainty about whether or not what the money's being spent on will be recoverable ultimately from the defendant, either because
Mm.
it's not reasonable or potentially some contributory negligence. And also then the stress about, well, when's the next interim payment coming from? Because we might have £100,000, £200,000, but that's not going to last forever.
Yeah.
And sometimes claimants are reluctant to spend money because they don't know when the next interim is coming from. So, part of our job as claimant solicitors is to ensure that that flow of funds continues, and to try and reassure claimants that that will be the case. But it's not easy, and it's not always possible to ensure that that flow of funds will continue without objections from the defendant or the need to make applications for interim payments. But the question of funds is a major stressor for claimants.
Yeah, and it's a good reminder, actually, isn't it, Dan, for lawyers and treating rehab teams and people surrounding the claimant, that although it's tempting to kind of breathe a sigh of relief,
Yeah.
actually, thinking beyond that initial, okay, we can cope for now. But okay, so I wanted to just delve into a bit more of the specifics that we were talking about in terms of the
Mm.
process of litigation. So can you just talk us through kind of the main kind of spike points during the process that are likely to result in a higher degree of stress for claimants?
Yeah, I mean, the first thing to say is that every case is different and every claimant is different, but there are a number of themes that we see time and time again. And I think the real spike points I'll leave aside trial because very few cases actually go to trial, but spike points tend to be around disclosure, around witness statements, and around expert appointments. So in
Yeah.
relation to disclosure, if you think about what we actually have to do as lawyers and what other members of the team need to do, we're providing huge swathes of documentation and information to not just the defendants, but to the treating team, to experts, to counsel. So by the end of a case, tens, dozens of individuals might have pored over um, documentation, information about the claimant. And bear in mind, it's not just information or documentation that's come into existence post-injury.
Yeah.
Oftentimes, we'll have to disclose documents that relate to a claimant's life before they were injured. It could be their employment records, or obviously their GP records, or their DDBP records. And so, documents that claimants might have expected, not unreasonably, would be private documents that no one else would ever see, suddenly become the focus of the attention, and people start to look and query these things and form a judgment about claimants based on things that happened even before they were injured. That's a huge cause of stress. If any one of us thought that our most personal information was going to be poured over by teams of individuals, some of whom would have vested interest in making you out to be unreasonable, that's a hugely stressful experience. And so what we need to do to claimants is to explain the process, explain the rationale, manage their expectations, not shirk from um, you know, disclosing documents, but also only making sure we disclose those documents that do need to be disclosed and resisting any suggestions from defendants that documents that aren't relevant do need to be disclosed. So curtailing what needs to be disclosed.
Mm.
Witness statements are a major issue for claimants as well. The difficulty from our point of view as lawyers is that the witness statements need to be in the client's words. Sometimes clients say to us, well, you know what's happened to us, just write my statement for me. But we can't do that, obviously. It needs to be in the claimant's words, it needs to be their evidence. But what does that mean in practice? In practice, it means that you're going over events that have been incredibly traumatic and stressful events and almost forcing claimants to relive that, opening up old wounds. They're, they're probably feeling things that they may have pushed to one side and tried not to think about for some time, but you have to get into these issues sometimes. Um, it's an incredibly stressful experience. You also have to tell claimants that if information isn't in their witness statements, it may not be admissible as evidence. They may not be able to talk about it at trial. It has to be a full and frank um, account of what they've been through, etc. So that in itself causes stress. That claimants thinking, oh, I need to make sure everything's in there, and I don't want to leave things out. So how do we reduce that stress? Well, I think one of the things is to do is to explain the process to claimants so they understand the purpose of a witness statement. I think that by breaking it up into smaller sessions so that claimants aren't doing it all in one go, but giving claimants a heads up beforehand about, well, these are the issues that we're going to explore in today's session. We're going to want to talk about, the accident or the events in the weeks and months immediately after the incident. We're going to have to talk about X, Y, and Z. So you give them a heads up. They've got some time to kind of steel themselves, to prepare themselves for the session. Um, I think there are things you can do to mitigate the risk of it causing stress, but I don't think you can avoid it entirely. And then,
Mm.
I mean, expert appointments. Anyone who's involved in litigation, case managers, treating teams know how stressful these are for claimants. Holly King, who many people on this call will know, produced a really good paper a year or so ago about how claimants can become re-traumatized in the context of medico-legal assessments. And I'd encourage people to read that paper and what steps can be taken to reduce the risk of claimants being re-traumatized. And one of the things is, briefing your experts properly, asking them not to ask unnecessary questions like, how were you injured? When, it's there in the letter of instruction. Um, there's real anxiety about claimants on being believed. They want experts to believe them.
Mm.
Um, they get stressed about, do the defendant's experts have an agenda here? Are they out to get me? Um, So that's the appointments itself, having to go over all these things, being asked the same questions by, potentially, 15, 20 experts when you look at both sides experts. And then what happens? They go to the expert appointment, and then there's weeks, sometimes months before they know the outcome of that. Even with their own experts, there's uncertainty about, well, what's the expert going to say? What's their opinion going to say? Um, that period of time between seeing the expert and knowing what's in their report, and when the defendant's report, sometimes it can be months or even years before you know what it's going to say. That kind of nagging doubt, is that expert going to believe me or not? What are they going to say about me? That can be a real stress for claimants. So it's I think it's the kind of perfect storm for claimants. There's a lack of control. They can't control what an expert's going to say. There's a huge invasion of privacy, and the experts are looking into all aspects of their lives. And that uncertainty which it generates is a real problem for claimants. All we can do as lawyers is make sure our experts are briefed properly, manage client expectations, try and ensure that the defendant's experts are good experts. You can object to the selection of a defendant expert if we know they've got a track record in making your claimants feel really uncomfortable. But you can't remove that risk, but it's being alive to that risk. And we'll come on to discuss, what steps the legal and the treating team can take to address those issues.
Yeah. I mean, in thinking about some of the issues, Dan, it strikes me as well that there's a different type of pressure upon litigation friends. In
Yeah.
cases where you have a very injured claimant and you have a family member or someone close to them acting as a litigation friend, that stress kind of takes on a different meaning in terms of it's almost you're making decisions and making calls and uh, that have an impact upon someone
Yeah.
else's life for the
Yeah.
remainder of their life. And that is, I mean, we could do a whole other session on that, couldn't we?
Yeah.
So
Yeah.
we won't go into it, but I just wanted to acknowledge that, it's such a broad spectrum of people that are impacted by this. And if only we had time to talk about that more. But I wanted to just move us on slightly and talk about we talked about the process, and I want to focus upon kind of the effects
Hmm.
that litigation stress might have upon claimants. And now I mean more, I think, than affecting their well-being just by the
Hmm.
virtue of being stressed, of course, which is awful enough in and of itself. But I wanted to look at other effects that this kind of stress can have and how that might manifest itself in the litigation.
Yeah. Again, given the limited time, we've got to speak in kind of in generalizations, and you could do an hour on this single topic about the effect of litigation stress on claimants alone. But I think some of the things we often see is a refusal or a reluctance to engage in rehab, either because of the stress about the expense of it, or the ceding control, or the divulging personal information to the rehab team. We can see, as you say, an exacerbation of existing psychiatric or psychological symptoms. We can see that claimants so desperately want to be believed by the experts they go and see, particularly defendant experts, that they can sometimes be a distorted presentation. They're trying too hard to convince an expert of the difficulties that they're facing, which can then lead, as we know, to potentially allegations of dishonesty or exaggeration, which, the Lord knows that brings, a whole different type of stress. It can cause a breakdown in relationships, whether that's the claimant's own relationships with their family, or the relationships between the claimant and their legal team, or the claimant and their treating team, their MDT. And I suppose one thing that we see, not often, but we do see it from time to time, is a desire on the part of claimants to end the litigation at any cost, even against advice. They just want the litigation done and dusted, and so want to end it at a time where perhaps it's not really the best time to conclude it, or just end the litigation on terms that we don't think are particularly favourable to the claimant, but the claimant just wants the litigation to end. And so you sometimes have to try and protect the claimant against their own instincts there, and advise them not to conclude the litigation. But it's tricky, because if a claimant's got capacity, they can make a decision about what they want to do.
Yeah. And I mean, all of those things that you've mentioned, Dan, you know, the breakdown in relationships, distorted presentations, all of those can have a significant impact upon outcomes for the claimant in different ways. You know,
Yeah.
taking a breakdown of relationship, is that going to have an impact upon care provision, or, you know, community provision or support, you know, and kind of us, it's important, I suppose, for us to adapt to any changing circumstances or risks, and highlighting those for experts and claimants in the case and
Yeah.
exploring those. But again, we could do a whole session just about that. But just to wrap us up, Dan, I do this to everyone, and you're no different. I'm going to rinse you for your practical top tips for trading teams and for lawyers, in terms of, you know, what can we do and what can we think about doing to support claimants from a practical perspective in managing stress.
Yeah. I mean, the first thing to do is to be aware that litigation stress exists, you know, and to ignore that would be to ignore the real problems that it can cause claimants. So the first thing to do is to acknowledge that. The second thing to do is I think is to kind of adopt a whole team approach. And by team, I mean kind of the legal team, the treating team. There'll be things that both parts need to know about. So one good idea is for example, is something which we've done in a case you and I, Emma, recently, is to adopt a shared calendar with the treating team, so that the treating team are aware of when certain events in the litigation are going to happen, so they know that the claimant might need additional support during those particularly stressful times, but also for the litigation team to know about what's happening with, you know, when is a neuropsych session taking place, or when is a physio session taking place, or what have you, so that we can plan the claimant's diary in terms of their interactions with us. Let's not have a day when we're doing a witness statement on the same day or the day after a particularly tiring session for the claimant. Let's make sure that a claimant is best equipped to deal with what we're asking them to do on any given day. So I think it's about communication. It's about ensuring that all parts of the claimant's team, treating and litigation team, are alive to what other parts of the team are doing at any one point in time. I'm not saying that avoids the stress, it doesn't, but it might help to reduce the stress, or at least provide some sort of support framework for the claimant, or better support framework for the claimant to deal with the stress that they're experiencing.
Yeah. Thank you so much, Sam. As I said, we could do, and you did a talk on
I
this
did.
topic for, I don't know whether that was recorded or not. If it was, I'll find it and I'll post it. And if it wasn't, I'll find the link. There'll be some write up in relation to it, which will probably have links. But I'll make sure that all the stuff that you've mentioned today is linked, Dan, and anyone that wants any further information or wants to ask a question, please feel free to get in touch with Dan or me.
I'm sorry for running over. 23 minutes is longer than we're
Do,
supposed to be, but
do you
it's
know
a
what?
topic that we could talk for 2 hours on.
We absolutely could. This was just a taster, and to get people thinking about kind of the main themes and issues, and hopefully given a slightly different perspective today on these issues. But thank you very much, everyone, for joining us again, and enjoy the last bit of the warm weather, and we'll look forward to seeing you all soon. Thanks, Dan. Thanks, everyone.
Bye.
Bye.